We have quorum now.
This meeting is being recorded.
6:03. Patience. We'll go ahead and start the meeting. Let's please take a roll.
Commissioner Lyday.
Here.
Commissioner Diaz. Here. Commissioner Bray. Commissioner Wagner.
Present.
Commissioner Kreiner.
Here.
Vice Chair Hardy. Chair Vang.
Here. We'll go ahead and we'll do the Pledge of Allegiance. Everyone, if you can, please stand. Ready? Begin. Pledge of Allegiance. Next, I'll go ahead and read the procedures of the meeting. This meeting is being conducted in person and electronically. The public may participate in tonight's meeting by using the Zoom link provided on the Planning Commission agenda. Please note that all virtual participants will be on mute until they are called upon by the chair, at which point they will be unmuted. If you are a member of the public and would like to comment on an item, use the raise hand function on Zoom. To avoid any confusion, please wait for the item you desire to comment on to call by the chair before electronically raising your hand. For each matter considered by the Commission, there will first be a staff presentation, followed by a presentation from the project applicant. Testimony from supporters of the project will then be taken, followed by testimony for those in opposition. The applicant will have the right to a final rebuttal presentation prior to closing the public hearing. In accordance with Section 13 of Article 2 of the Planning Commission Rules and Regulations governing length of public debate, all public testimony from those in support and in opposition to the project will be limited to 3 minutes per person. The 3 lights on the podium next to the microphone will indicate the amount of time remaining for the speaker. The green light will be turned on when the speaker begins. The yellow light will come on with a cell bell ring when 1 minute is remaining. A speaker should be completing the testimony by the time the red light comes on with the final bell indicating time has expired. All in-person public testimony must be presented to the Commission at the podium. Any testimony that references race, religion, ethnicity, economic status, national origin, or any other classification protected under state or federal law in a derogatory manner shall be deemed irrelevant and will not be considered by the Commission in making its land use determinations. If you challenge these land use matters in court, you may be limited to raise only those issues you or someone else raised in oral or written testimony or before the close of the hearing. We'll start today's meeting with the approval of the agenda. Do we have any changes to the agenda?
Good evening, Chair Vang, Commissioners. Philip Segrist with the Planning and Development Department. There are no changes to tonight's agenda.
Awesome. Thank you, sir. Do we have a motion to approve the agenda?
I'll move to approve. Second.
All right. So we have a motion by Commissioner Bray, second by Commissioner Diaz. All in favor say aye. Aye.
Aye.
All opposed say no. Motion passes. Next, under consent calendar, we have January 3rd meeting, regular meeting minutes. Do we have a motion motion to approve the consent calendar?
Motion to approve.
Second.
All right, we have a motion made by Commissioner Diaz, a second by Commissioner Kreiner. All in favor say aye.
Aye.
All opposed say no. No. Motion passes. Do we have any reports by the commissioners? I see none. We'll go ahead and go to continue matters. This is ID 24195. This is continue from January 3rd, 2024, consideration of an appeal related to zoning inquiry number P2302357.
Good evening, Chair Vang, Commissioners. Philip Segrist with the Planning and Development Department. Tonight for your consideration is an appeal of zoning inquiry application number P23-02357. So the subject zoning inquiry pertains to an existing tow yard, which is approximately that's located between West Vorman Avenue and West Nielsen Avenues, and just west of North Thorn Avenue. Thank you. Also the tow yard is also owned and operated by Bowers Towing. And before going into a little more detail on the specifics of this specific zoning inquiry as well as the appeal, I'd like to provide a little brief overview of zoning inquiry applications. And so if you recall, several months ago, Planning and Development staff did provide the Planning Commission with a workshop on the development code, which included a general overview of various application types that typically planning processes, as well as those that come before the Planning Commission. And those would typically include plan amendments, rezones, conditional use permits, development permits, text amendments, and what have you. Also, during that discussion, there was an overview of some of the other entitlements that planning staff does process, such as temporary use permits, minor revised exhibits, minor rear yard encroachments, and one of those is the zoning inquiry. So aside from that, zoning inquiries are one of those applications, and there's, per the code, the request for formal interpretations of the development code, as well as verifications relating to prior approvals or permits, or confirmation of applicable zone district zoning for a parcel. And in addition, applicants request to verify whether or not a specific use might be permitted at a site, or you can verify whether or not an existing use at a site is either legal conforming, legal non-conforming, or illegal and non-conforming. And you also can verify whether an existing building or site feature can be replaced if damaged or destroyed by either fire or natural disaster. It's important to note that zoning inquiries are ministerial, and they're not a discretionary approval, so they're not subjective in any way. And according to the development code, zoning inquiries, while they are ministerial decisions, can also be appealed to the Planning Commission. And as previously mentioned, the subject zoning inquiry and appeal pertains to Bowers Towing, which is an existing tow yard located at 371 West Vorman Avenue, which is owned and operated by Edward Mason. And before getting into the specifics of the particular zoning inquiry application, it's important to provide a little bit of background on tow yards within the city of Fresno and how those are processed. And it's noted that the following background info that I'm going to present is also included in the staff report, as well as in the zoning inquiry response that staff had already prepared. So starting out, there's Director's Classification Number 208. That was approved by the Planning and Development Director in June of 2010. And this director's classification established the use of towing, storage, and lien sales of impound motor vehicles as being a permitted use in the M3 zone district, subject to a site plan review and additional requirements. Primarily those being that they're provided for minimum area and storage capacity for tow yards, as well as screening requirements and the provision of security, as well as paved or other alternative surfaces be provided for the outdoor storage areas. And subsequently, in June 14th, 2011, the Planning and Development Director approved policy and procedure number C-002. And that provided the planning and development staff, as well as the police department, as well as tow operators, a way to verify whether or not a tow yard was legally established or a legally allowable use on a specific site. And it's important to note that the vehicle storage areas, under this policy, vehicle storage areas needed to be or must be paved per Public Works Standard P21. And in addition, a grading plan and permit would be required for the installation of pavement on the site. And going to this next slide, just for reference, this is Public Works Standard P21. Those are cross sections of paving for parking lots. So you have parking lots, standard parking lots, as well as industrial parking lots and loading zones. And the highlighted section shows that there's asphalt concrete as a top surface, as well as aggregate base. Not aggregate base on top, not other alternative surfaces. So for P21, it must be a paved concrete surface. And continuing into some of the background on tow yards, the City of Fresno non-exclusive franchise tow agreement for the Fresno Police Department, which was adopted by Fresno City Council on October 20th, 2011, established rules and regulations that tow companies must comply with to participate in the Fresno Police Department's tow operations. And tow yards participating in the rotation program and that are located within the City of Fresno must be in compliance with the Fresno Municipal Code, as well as the Director's Classification Number 208, as well as following the policy and procedure number C-002, which includes requirements for security and permanent paving and storage areas. And so, as detailed in the staff report, leading to the adoption of the tax service agreement, a number of tow yard businesses went through a zoning inquiry process as a way to verify that they did comply with all the requirements, including C-002. And so Bowers Towing Company, they were one of those tow yards that went through that process. And so they submitted zoning inquiry application number Q11-35. And with that, Bowers Towing was verified and added to the police department rotation list. However, it's noted in the staff report as well as in the appeal letters that the approval was conditioned upon vehicle storage area being paved and that the applicant shall apply an additional layer of base rock. It's noted as the staff report that base rock, as I previously mentioned, base rock is not in compliance with policy and procedure the Public Works Standard P21. And as I previously mentioned, Bowers was on the rotation list, but as unspecified reasons, Bowers was removed from the police department rotation list. However, that removal was appealed and it went to an independent hearing, and an independent hearing officer did order the police department tow unit to reinstate Bowers to the rotation list. However, it was subject to compliance with the current tow service agreement, as well as applicable Fresno Municipal Code requirements and the policy and procedure number C-002. which requires the permanent paving. Fresno Police Department tow unit during that time, so they were added to the list. However, the police department tow unit did do a site visit to verify were they in compliance with it, and it was determined that they were not in compliance with the policy and procedure -C002, as the vehicle area, storage areas were paved with base rock and not paved with asphalt concrete. And therefore, the police department didn't provide tows. While on the rotation list, they didn't provide tows because they were not in compliance. Okay, and this next slide is an aerial image of Bowers Towing. I forgot the highlight on there, but they are the middle parcel, not the vacant parcel with the building, but the one with the vehicles that are located in the southern portion of the lot. You can see the area around it. There's not typical paving of what you would see, like a concrete, asphalt. In addition, here are some site photos from the police department that show lack of paving at the site. And so therefore, in order to remedy the situation, the applicant was directed to submit a zoning inquiry application for planning staff to verify whether or not, are they in compliance with the policy and procedures, and so the applicant did submit a zoning inquiry application, the one in question, P23-02357. In addition, the applicant, with zoning inquiries, applicants can request they can ask questions and staff will provide responses. So the applicant requested for the planning and development director to confirm that the use of the property for a tow yard satisfies relevant zoning laws of the city of Fresno based on facts and evidence, as well as alternatively, the applicant requested that the planning director provide a statement of the specific circumstances that exist at the site that would result in a violation of zoning laws or and particularly any violations of policy and procedure number C-002. And so, as typical with a zoning inquiry, staff perform research based on evidence in the record, past history, entitlements, including the prior zoning inquiry application. And based on the current zoning, the zone district is zoned for heavy industrial, and according to the code, that is a permitted use with a conditional use permit. And so they don't have an approved conditional use permit, and therefore staff determined that they are a legal non-conforming use. And further, staff determined that Bowers Towing is not in conformance with policy and procedure C-002, as they don't have permanent paving in the vehicle storage areas. And given that they're a legal non-conforming use, that absent any kind of expansion or a change of use, they can continue indefinitely. They just aren't in compliance with the requirements for the tow yard, or for the tow rotation list. And so following staff's response and determination with our zoning inquiry, the applicant did appeal staff's decision. And they appealed our zoning inquiry response on the basis that the prior zoning inquiry under Q11-035 verified that Bowers Towing Company was in compliance with the requirements of policy and procedure C-002. So in response to the appeal, staff's analysis maintains that the areas where the vehicles are parked, stored, or driven at Bowers Towing Company is paved with base rock, which is not an approved alternative surface which is an approved alternative surface under Director's Classification C, Director's Classification number 208. However, policy and procedure C-002, which supersedes that, requires those storage areas to be paved per the Public Works Standard P21. And in addition, City of Fresno Public Works Department has confirmed that base rock doesn't comply with the paving specifications under that Public Works Standard, and therefore the establishment doesn't comply with policy and procedure C-002. And it's noted that there are no appeal rights for older or prior verifications, such as the Q11-35. And so both the Director's Classification number 208 and the Policy and Procedure number C-002 have been superseded by the codification of the new current development code. So in short, the current development code doesn't require permanent paving, but in order to be a participant of the rotation list, they need to comply with the policy and procedure, which requires the permanent paved surface. And so the subject application of the appeal was previously scheduled for Planning Commission. It was previously scheduled for January 3rd. It was continued. The appellant did provide some additional information and material that was included with the staff report. That was included in an attachment. However, there was one attachment that they did provide that day as well that didn't make it in that attachment. However, the applicant did bring it here to the commission to provide. After reviewing it, staff still maintains that the surface areas for the tow yard where vehicles are stored are not in compliance with the policy and procedure C-002, and that the use is legal non-conforming and can continue to operate. And therefore, staff recommends the Planning Commission deny the appeal and uphold staff's determination. And it's also noted, as I previously mentioned, there aren't any appeal rights for prior or older zoning verifications. And so therefore, the Planning Commission can really only consider the appeal of the director's determination under the subject zoning inquiry, and that the subject tow yard is a legal non-conforming use pursuant to the development code. That concludes staff's presentation. Available to answer any questions. The applicant and his representative are also in attendance and have prepared a presentation should the commission wish to see that.
Thank you. Do we have any questions?
I do.
Go ahead.
So I've carefully read this most of today to try to figure out what happened. But listening to you and seeing what I have in front of me, it sounds like, and you can tell me if I'm wrong, in 2010 or 11, this was okay. And then the C-002 was later instituted, which made it not okay. Is that what you're saying?
That would be correct. In 2002, there was the director's classification that said the storage area should be paved, or that another alternative surface, such as gravel, would be okay. And then that was superseded by the policy and procedure C-002, which was approved in 2011 after that then said that the storage areas needed to be paved per Public Works Standard P21, which is asphalt concrete, not alternative surfaces.
And so there's this, I'm sure you know, there's this declaration from Mike Sanchez that he looked at it and approved it, and he was the planning staff at that time. So how did that happen?
That I do not know. I mean, I'm not going to say that letter did not say that was okay, but based on the fact that there isn't paving out there, we're looking at it on the facts that we have at hand. Is it in compliance with it? Is it not? And I'm looking at it at today's standards. So staff determined that they are not in compliance with the C-002 policy.
Although they were told they were
I would.
in compliance with something in 2011. Is that correct?
So,
Debate.
just to be clear, that that issue of 2011 is not what's presented to you today. What's presented to you today is the zoning inquiry that came in July of 2023 in the state of the tow yard at that time, as well as I think that there's been discussions or disagreements, I guess, back and forth about whether that says that they were okay or not in 2011 or not.
you.
Do we have any other questions?
Further clarify, this isn't necessarily whether or not they can maintain their towing operations. This has more to do with the ability to be a vendor for the police department to tow to, correct?
That's a correct statement.
Thank you.
Do we have any other questions? Thank you. Appreciate it. Next, I'm going to go ahead and we'll invite the applicant to speak in concurrence with Section 13 of the Planning Commission Rules and Regulations. We're going to allow the applicant to have 10 minutes for the presentation. Okay?
Thank you. I'm not familiar, Brad Bolden, I represent Bowers Auto Wrecking and Towing. I'm not sure how to work the PowerPoint here, but I did kind of want to skip and maybe go to slide 3. Do I just?
He'll pull it up and it's just left and right.
Okay. First of all, I want to say one thing. My client was obviously approved in 2011, and it was a COO2 approval. The author of COO2 was Planning Manager Mike Sanchez, and he signed COO2 on behalf of the Planning Department. He was also charged with approving over 35 towing companies, some of which I don't believe made it. My client obviously signed the tow service agreement in 2011, 2 months after the August 5th, 2011 approval letter. I know that the city's position is we're not talking about 2011, but the whole reason we're here is they said you were never approved in 2011 because you need to be paved, right? The problem is we paid for another zoning inquiry for $510 and nobody came out to the property and physically stood in the yard. They just used aerials or the police department's word, and the police department does not work for the planning department. The police department didn't kick the ground or look. They didn't do the inspection in 2011. So we're looking at somebody who came in at 2023, who's not a planning department trained person, did an inspection and just relayed it to the planning department, who we asked to come out and look at the property, but failed to do so, despite filing a zoning inquiry. Is there a way to get up? Okay, so we are here. So I'll skip some of this because it's already, it was a wrongful conclusion. Now, what we did was on November 28th of 23, okay, long after the September 26th, 2023 Planning Department zoning inquiry letter in response to our zoning inquiry, about 2 months later, we hired somebody to come out, and we first, if you see the kind of rock pile in the middle of the yard on the left, is there an arrow or something that I can? No. If you look at the non-green area highlighted image, yes. In the center, the non-green, sorry, the other side, there is a pile of rocks that my client pushed off. And you can see a clear delineation that matches the illustration on the right. And that illustration shows that there's well over 6,000 square feet of pave area that the planning department is apparently still unaware of, despite the fact that it even has pictures in your file from 2011 showing concrete. It's one of the exhibits. We did a Public Records Act request, and I don't remember getting those or seeing those, to be honest. We got nothing from the planning department for a very long time, except for the approval letter, which we already had. Now, my client's not going to wait for 2 months and do nothing and not file a grading permit if he was told he needed to be paved. He will come up and testify that he was told by Mike Sanchez, you're good to go. Don't worry about it. 2 months later, he gets a call from the PD. You can't surreptitiously log in and just sign a contract without the PD knowing about it. They call you in, they called him in, he signed it 2 months after the approval letter. And so this shows you that there's clear paving there, and it's well over 5,000 square feet. And Director's Number 2008 and the TSA required 5,000 square feet of or more of paving. So we have it. There it is. This next photo, you'll have to look at the middle where all the cars are. This was a Google Earth image that I believe existed for quite some time that may or may not be what the planning department used to determine that it's dirt or not paved. And you cannot see the delineation. It would be in the dirt area in the middle of the slide. You don't see that delineation where you clearly did in this one. If you look, they're taken from different views, but you see right there, there's a line of pavement. It's very, very apparent. And here it's not. And this one's from November 5th, which predates the time that my client moved all the base rock off. And again, 2011 is absolutely relevant, because you're going to see in the next slide that he was told to add base rock within 6 months as necessary. You don't require someone to get paved and then later add base rock. It doesn't make sense. I even asked my 6th grader, and she said that doesn't make sense. Obviously, it says maintain a paved surface, which means Mike Sanchez knows that it was paved. He is the only one in the zoning inquiries, one from 2011 and one from 2023. He's the only one that kicked the ground. And he's the one who saw the paving, and he's the one who approved it, and he wrote COO2, and he signed the letter. So we got all these contracts going, and we're ordered not to be re-inspected, not to be treated as a new tow company, but to be reinstated, to comply with the TSA. The TSA dovetails back, and this is why 2011 is so important. The TSA dovetails back to COO2 as it was approved in 2011. There were no further amendments to COO2 between 2011 and 2023. So if we passed it in 2011, there's been no complaints, we have paving, why were we not granted passing of COO2 right now? Especially with the defectiveness of the inspection. If we keep going here in the slides, I want to look at the language. This is taken out of the approval letter from August 5th, 2011. Remember, just 2 months before my client signed the 2011 TSA. In the first part, on the first page of the letter, which is an exhibit called the approval letter, I believe, it says, as a legal nonconforming use, the site may continue to legally operate as a tow yard. Okay? And then I want you to take note, the next portion that says, as a legal nonconforming use, the next sentence right there, underlined in red, all existing tow yards shall comply with the following minimum conditions. And that's 6A from the letter. The areas where cars or vehicles, parts are stored and vehicles drive must be paved. That was read to you by the City Planning Department. That's part of CO2. It's copied and pasted here as a general supposition that all tow companies must meet. However, the next 2 sentences begin with the word applicant, which specifies, now we're talking about Bowers. Bowers, what do you need to do? Well, you got to maintain a paved surface. We're trained to use plain English when we read something. It doesn't say you must get paved. It says you must maintain a paved surface, okay? And pursuant to Exhibit A1, we're going to get there. But you'll see A1, and I only really, you could see the attachment through the bulk of what I've presented, but the attachment that I have is just some words from there. It says, applicant shall also apply an additional layer of base rock as necessary within 6 months of the date. You don't require someone to get paved and then put base rock on, okay? We never would have signed the TSA in 2011. Mike Sanchez would have flagged and said, not approved. Moreover, under the FMC here, and I believe it's section, if you want the number, it's section 15402. We had to pass COO2 to even get a legal nonconforming status. So for them to say we didn't pass the CO2, we don't think they did because they weren't paved. Oh, if they weren't paved then, and we said they needed to be paved and they didn't do anything, they're still not paved. I guess they just very quickly just move this through. But they didn't see, and they wouldn't come and look, that it's paved. Now, Bowers was grandfathered in because it was in existence, I think, towing since the late 80s. And in 2006, since they were there and they were grandfathered in. And so he did not have to file a conditional use permit. And that's part of the reason why he got a legal nonconforming use. Okay? It doesn't relate to just towing for vehicles that are not related to the towing yard. And so you can see even the language is clear. Even when you look at CO2 procedure, it says, hey, this is to identify to our public that this guy's a legit business and he's towing and it's fine. It says you're going to file a zoning inquiry, you're going to pay your money, you're going to get a letter. And he did. And we towed after that letter was adhered. Does that mean 1 minute?
That's correct.
Okay, thank you. So let's skip over here. Here's the language. We got some handwriting here from Mike Sanchez. Note, right in the middle, number 1, apply condition 6A per 8.5 approval letter. Not denial letter, not conditional letter, approval letter. That's Mike Sanchez's handwriting. That's why when I met with Mike Sanchez, he was so vehement that we passed. He remembered everything. He said, I'll sign a declaration. No problem. Okay, so what is the condition to apply in 6A? Remember, folks, it was add base rock as necessary. You don't add base rock to something that needs to be paved first. And this is Exhibit A1, 8511, front portion of the yard, storage area, and it's highlighted. Okay, so I did also include this section for you guys if you want to take a look at it as to what legal nonconforming status is. But thank you for your time. That's why we submit that we're approved then and we're approved now based on the paving that we have and the approval in 2011.
Thank you. Do we have questions? Question for you. So why were Bowers actually removed from the TSA list?
So that's interesting, and it's quite unfair. Bowers towed for over 35 years for the police department. Now, Ed's son has had a very minor troubled past, but he was a felon at the time, and he was living off the property. There was a gate. His grandmother owns the property. He had no key or access to the building, and he was not an employee because, quite frankly, he can't hold a job. No, disrespect to Ed, but I got to be truthful with you guys. So there was an assailant who had been in the yard, broken window, lots of theft going on. He called his father. He heard it. In the underlying appeal, there were 3 depositions from Sprint, PG&E, and another company that said the son calls anytime he hears anything in anybody's yard, he calls the police department. He's like free security, although he's not paid for it. He just does it out of the goodness of his heart. So he was afraid himself. He was a felon. He was expunging his record in the process of it. He had acquired a .22 from some friend. He called his dad and said, do you want me to jump the fence and flush this guy out? Because we need this guy to get arrested. They keep breaking in and stealing, property. So he flushes him out. The assailant jumps over, has a tussle with Ed Mason, the owner, and he fires a shot at him. And the guy runs away. And so because of that, the PD made up the story that he's an employee and you didn't get him fingerprinted, even though he'd been an employee before. Long story short, the DA's office dropped the charges against him because they said he was legal self-defense or defense of another for his father. But the PD had terminated him, not suspended. They wouldn't meet with us. We requested meetings with them. They terminated. We appealed. We won. At the end of that appeal, they said, I don't know what you're appealing. That TSA expired. So we had to file a second appeal to show that we should have been put back on long ago. And COVID has obviously extended this situation. So the second appeal, that's when on March 30th, 2023, the independent hearing officer said enough, reinstate them. You have 14 days to do it. We did everything. We met every burden except for this long drawn-out thing that we don't think you passed COO2.
Thank you.
And so there we are.
I appreciate it. Any other questions?
I have a question.
Go ahead.
Yes.
Prior to the current situation, about how much of the revenue for the business was generated by Fresno PD towing vehicles there?
I would defer to Ed, but it's significant to have that spot. Those spots are full, and there's a waiting list, and you can't get on until they get under a certain number, but it's a significant amount of income. He also tows for the CHP and the Sheriff's Department, but those don't have the volume that the city of Fresno has. Do you want my client to come up and tell you? Yeah, come on up and let them know kind of where you think what you lost monthly by not towing for the PD.
The revenue from the PD contract is probably worth Well, on a yearly basis, I would say it's worth a minimum of $300,000 to $350,000, and probably more, because what happens in our situation, we're an auto dismantler too. So the cars that don't get picked up, because when I'm telling you that amount of money is money that we collected for the cars that did get picked up, but the cars that are left behind actually end up in the wrecking yard, and then we sell those for parts.
And are the agreements with CHP and the Sheriff's Department still in place?
Yes, ma'am.
Do they have the same requirement for the paving that the city of Fresno does?
Well, the pavement part, no. I was told by Fresno PD that I could tow for, because the zoning said that I could tow for under that 208.
Director Steele.
Yeah,
I think he was told he can continue to tow for everybody else but the PD because he doesn't meet C002.
I was told by a sergeant at the PD that I could tow for anybody else because that's what the planning says, but I can't tow for the city of Fresno anymore.
All right, thank you. Any other questions? Thank you. Appreciate it.
Just one more thing. From the street all the way through the entrance, all that way through the green area is all paved. There's no like missing paving spots. And he has more than 5,000 square feet. And that's where he stores the cars that he tows for the PD.
Thank you.
So I just wanted to clarify that in case I missed it.
Thank you. I appreciate it.
Thank you.
We'll now go to the public. Any members of the public who would like to speak in favor? Go ahead. That's fine.
Thank you.
Please state your name, address, and you have 3 minutes, okay?
Okay. My name's Ed Mason. I own Bowers Auto Wrecking, 103 North Thorn. First off, the pictures that Mr. Sechrist showed you of the storage yard were not the storage yard. That was my wrecking yard, which is probably 300 or 400 feet away, completely different piece of property. There is pavement. There's always been pavement. It was part of the bigger building in that building. That used to be a brass factory, and we put a fence up. And that pavement has always been there, and we just smoothed it out with gravel. Per Mike Sanchez's blessing. I mean, he's the one that said to add a little bit in the low spots. There is more than 5,000 square feet. That's all the contract requires of pavement. That's always been there, but nobody ever came out to look. I mean, Mike Sanchez has been the only person that came out to look from the planning department. And I'm getting hammered by reports from a satellite 450 miles in the sky, and not anybody coming out and kicking the dirt themselves. I guess that's about where I want to be. Thank you.
Thank you. Appreciate it. Do we have any other individuals who would like to speak in favor? We have any individuals with their hand raised on Zoom?
Yes.
Please state your name, address, and you have 3 minutes.
Yes, can you hear me?
Yes.
My name is Jeffrey Reed. I'm an attorney at McCormick Barstow, 7647 Fresno Street. I'm also legal counsel for Bowers Auto Wrecking. I want to focus on statements in your staff report and from your counsel this evening that could create some improper limitations on your deliberations. Statement is in the last full paragraph on page 8 of the staff report, where they say that, no appeal rights for old prior zoning verifications, and that policy and procedure CO2 is superseded, and your commission therefore can only consider an appeal of the portion of the director's current verification that the tow yard is a legal nonconforming use. Those statements incorrectly suggest that this appeal seeks to overturn the city's old prior August 2011 evaluation of the compliance with CO2. That's not what the appeal is about. The appeal also does not seek to overturn the director's present confirmation that the tow yard is a legal nonconforming use. We agree, it is. What this appeal is about is the city's error in its current zoning verification as to what the city determined in August of 2011. This appeal asks that the city reaffirm rather than disaffirm its 2011 determination that the property satisfies COO2. To avoid you being able to provide us that reaffirmation, you're being told that whether or not the property complied with COO2 in 2011 is irrelevant because it was superseded. But it is relevant because the current zoning inquiry confirmation asserts that the property violates COO2. And that assertion is what the police department now relies upon to continue to frustrate the reinstatement of the appellant to the rotation tow list. That fact is confirmed by the October 2nd, 2023 letter from Lieutenant Anthony DeWall, which is included as Exhibit A to the December 28th letter submitted by Mr. Bolden that's in your agenda materials. And the letter states that the failure to comply with COO2 precludes Bowers from receiving tows under the tow service agreement. This appeal is about the appellant's right to have you reevaluate the portions of the zoning inquiry's findings that the police department is now using to keep the appellant from obtaining reinstatement to the tow list. There's a maxim of legal jurisprudence that for every wrong there's a remedy. And the remedy of this wrong is for this commission to revise the zoning confirmation and confirm that the property satisfies COO2 based upon the 2011 determination that the property satisfied COO2. The municipal code also states that to be a legal nonconforming use, the use must have been lawfully established, and it must also comply with any conditions imposed upon it at any time thereafter. COO2 imposed new conditions on then existing tow yards. That confirmation that the property is a legal nonconforming use therefore necessarily includes a finding that the property satisfied COO2 in 2011 when it became a relevant standard. Now, there's much substantial evidence in the record to support the finding, including the declaration of the city's then current planning manager, whose signature adopted policy COO2, and who details his prior deliberations and determinations that the property satisfied those standards. If the city staff now believes there's insufficient evidence to support that determination of the former planning manager, you cannot now overturn those determinations. That's because, as the city staff has stated, prior old verifications are not the subject of this appeal.
Let's go ahead and I'll let you wrap up. I'll give you 5 seconds, okay?
It's only the city's current misinterpretation of Mr. Sanchez's prior proper determination that is relevant to this appeal, and it's those current erroneous misinterpretations that we're asking that you overturn. Thank you.
Thank you, sir. I appreciate it. Do we have any other individuals with their hand raised on Zoom?
Not at this time.
Thank you. We'll go ahead and let's go to the public. Any individuals who would like to speak in opposition? If you'd like to speak in opposition. Do we have any individuals on Zoom with their hand raised who would like to speak in opposition?
Not at this time.
All right, so we'll go ahead and close all public comments. If I can have the staff answer some of these questions in regards to what the applicant presented, please.
Yeah, so staff, to my knowledge, never asked to go out and visit the site. And if it was as simple as demonstrating that the site was in fact paved, I believe the staff would be able to provide a photo of the site that shows that it's actually permanently paved with concrete and asphalt, not base rock. Furthermore, if it was paved, as he indicated, according to policy and procedure C-002, they are required to obtain grading permits for that. And so staff did look in the record for verification of any kind of permit submitted and approved for that site for grading, not able to find any. So based on that kind of evidence, I was able to say, no, it's not paved, does not have permanent paving. Let's see here. Oh, and in response to not providing a response to the public, the PRA request, staff did receive that request. I received it, compiled it, and provided it to the planning staff. Does not directly hand that off to the requester. There's a kind of a process, and I think it was either the city attorney's office or records department that fulfills that request. So whether or not it got there, I don't know.
So I have a question. So I believe I heard the appellant say that they had fenced off this paved area paved area that had belonged to a previous brass factory. So not knowing how long ago that was paved, is it possible that whatever the paving was done was before they were ever there, and so maybe, who knows how long ago it was, there wasn't a grading permit, they just took over a property that had pavement? That's my question. And if no one went out there to look to see if it was paved, it's difficult to understand how we got to this point without actually hearing from the staff. And I'm not discounting that the appellant's telling the truth, but if it's such a big deal, why didn't we look at it?
Well, staff had, based on the information, the photos from the police department that they provided, and I did request that they confirm that it is actually, in fact, the area where the vehicles would be stored and not the auto wrecking yard. And they did respond in saying, yes, that is it. Whether or not I'm relying on the police department to do that. And also, again, I think there's up to the applicant as well to demonstrate that they are paved. I mean, a simple photo would suffice.
Any other questions?
Chair, I would also state that, so for our purposes, whenever we review an application, it's the obligation of the applicant to provide the evidence for the record that is necessary for a determination. Determination needs to be made based on the evidence in the record. And in this case, the commission is determining whether or not to uphold this current zoning inquiry letter, or zoning inquiry, and to determine whether or not to uphold or overturn that particular zoning inquiry. And I would defer to the city attorney for any additional information, like the ministerial nature of the application.
So, Director, I saw the applicant did provide some photographs, which it was honestly very hard to tell if that was paved or dirt, just as the photographs that were provided by the planning department. So we did have photographs from both sides, and I don't know about anyone else, but it was difficult to see if it was dirt or paved. So it just seems like, we don't even know if it's paved, for sure.
So I just want to remind the commission, because I know that we had started our training process a little while ago, but didn't get very far into it. And one of the things that we did not cover was the ministerial process. And in zoning inquiries, those are ministerial processes, which means they are free from subjective information and everything is objective. So it's whatever's in the record, evidence in the record, plus the code. And that's where our decision sits. So it's basically kind of like a checklist. If they meet this, this, and this, and we can find that in the record, then they're good to go, and the planning department cannot deny it, and vice versa. They can't approve unless it's this, this, and this, and that's it.
Got you.
I just don't see how photographs that you can't tell what it is are objective. I think it's subjective to look at the photographs and say, well, that's not pavement, or that is pavement.
There's no clear evidence in the record that it is. So we would need clear evidence in the record that it is.
That's what I'm saying. So if we have to be objective and not subjective, looking at photographs that you can't tell what it is very subjective. So I'm just stating that because I don't really understand what we can do about this unless we objectively know that it is or is not paved.
I think for that reason, personally, just hearing, because I sympathize with the business owners, and I know where the city's coming from too, especially if we're looking at things objectively, right? And I think making those points that you made, Commissioner Bray, I feel comfortable with pushing this to a forward date where if the applicant, I know this is very important to you because this is generating a decent amount of revenue too, right? So I would encourage you to really work with the city staff to prove that it is paved. And I don't feel comfortable with making any kind of decision right now. I'd much rather us just push it to a forward date, have the responsibility on the applicant to prove that it is pavement, just because last thing I want to do is set any kind of precedent, right? So that would be my apologies, but all public comment and any comments from the applicant is closed. I'm going to make a motion right now, just saying that I'm going to go ahead and push this to a forward date. Not, do I have to give a certain date or no?
I would.
Okay. What's a month from now? No, my apologies, but all comment is closed. We're looking at the 6th.
So it'd be March 6th or March 20th if you're
Okay.
looking at next month.
Well, let me go ahead and what I'll do is 6, 7. Let's go ahead. I'll make a motion to move this to March 6th. Okay, with the encouragement of the applicant to work with the city staff to hopefully prove and understand where the city is coming from, where they're trying to be as objective as possible in the matter. So that's my motion.
Second that motion.
Okay. So I have a motion, Commissioner. Do we have a second?
Second.
Second. Okay. Second by Commissioner Bray. All in favor, say aye.
Aye.
Aye. All opposed, say no. Motion passes. Do we have any reports from the Secretary?
No, tonight I do not have any reports. Thank you.
Thank you. Any unscheduled oral communications? I see none. It's currently 6:57. Meeting is adjourned. Everyone, have a good night.